All right, welcome. We're going to start our Q&A webinar very soon. My name is Ali Talai. I'm a trust and estate planning attorney. My law firm is here in City of Woodland Hills, and we practice estate planning. We do simple estate planning, trusts, will, revocable living trust, and more advanced estate planning like asset protection and estate tax planning, filing gift tax returns and estate tax returns, probate cases, and also trust administration. We have different webinars. We have a webinar that is intended to really explain further about different estate planning options and how a revocable living trust works and what things to keep in mind. That is a webinar that you could go to our website if you want to register for something like that. Under the event part, you could register for that. This thing here, this Q&A session, is really intended to get individuals that are interested to get more information about estate planning. And if there are questions that you have and you want to kind of figure out how to get answers to them and how to put your trust together, that's the goal of this session. So all right. So I see some people here. Mehdi, I see you. I'm assuming you can see me now. It says you're waiting for me to start. So I have started. You could put your questions in a chat, and I will do my best to answer your question. All right. We have 73 people that have registered for the Q&A session, and I'm sure we'll get more people to join. But the floor is open. You got a question about estate planning, asset protection, trust administration, probate, will, property tax reassessment, please go ahead and ask. Hi, Nina. The way you would ask your question is right here in the chat box. You could type in the question that you have. All right. I have some question that I had gotten before, so I can start with those, and then hopefully maybe those are some questions that you had in mind. And then also, if you think of a question you want to go ahead and ask, please go ahead and do it. I'm going to have the webinar for about an hour, maybe a little less, depending on the type of questions that we get. One of the questions that I get asked a lot is, what is the difference between a will and a trust? And do I need a will or do I need a trust? That's sort of a question that is asked almost every day. And it depends really. It depends as far as how we're going to set up your estate planning. There are three main differences between a will and a trust. And kind of getting familiar with those differences would allow you to figure out what would be a better option for you. The reality of it is we all have some sort of an estate plan in place. Every state, including California, has intestacy laws, and it says that if you don't put an estate plan together, you're pretty much going to fall back on what the government of California has put together for you. And so you can choose to overwrite that, and you could overwrite that by writing a will or doing a trust. And now the question becomes, well, do I do a will or do I do a trust? One of the first differences between a will and a trust is that when you set up a will, when you write the will, there's certain formalities that you have to follow as far as how do you get it signed? Does it need a witness or not? Usually in California, if it's a typed will, let's say you come to see me and I, as your attorney, prepare a will for you, then it will have to be executed by you, dated, and also we want to have two disinterested witnesses watch you sign and at the same time sign the will as a witness. But, putting aside the formalities of a will, the reality of it is that a will becomes effective after the person passes away. So I write a will right now, I do all the stuff, great, the will is there, it's executed, but it really doesn't have any power until I pass away. And then you compare that to a trust, a revocable living trust, and the reason they call it a living trust, the reality is that most of the trust, when you execute them, again, has to be notarized or doesn't have to be notarized. Again, there are certain formalities that needs to be completed, but the reality of it is after it's executed, it gains its power right now. So it becomes a living document, let's say, and it has power right now. So that's one of the big differences between a will and a trust. Matthew, I see your question. I'll try to answer that right after this one here, as far as talking about differences between a will and a trust. So the when they become effective is one of the first thing, the difference between a will and a trust. The second thing is we can do incapacity planning, mental incapacity planning in a trust, but we're not able to do it in a will. And the reality of it is that is because the will doesn't become effective until the person has passed away. So even if I write a will and I write in there that if for some reason I'm mentally incapacitated, I want my spouse to be able to make healthcare decisions or make decisions and do things for my assets and for me, it really doesn't matter because that document doesn't become effective until I've passed away. And obviously, if I've passed away, I have no mental incapacity anymore. We're past that stage. So in a will, we cannot have any incapacity planning in there. And again, I'm referring to mental incapacity. When you compare that to a trust, because you execute it today, it becomes a living document. You can do incapacity planning within a trust. And so you are able to do more and better planning usually within a trust as you compare it to a will. And the third main difference between a will and a trust is that a will cannot avoid the probate process for the assets that you have. So you have written a will. Going back to option one, which was doing nothing, that's really easy to implement. You've already implemented it. Very low cost upfront, at least. So the difference is that if you write a will, you could say, I want my assets to be divided, in a different way than what California laws would have you do it. But either way, in order to administer the will, there would be a need to go to probate court. But then when you compare it to a trust, when you have set up a trust and you've transferred your assets in there, you have placed your home in there, your business, your bank account, you tie them in there somehow, then at the time the person passes away, the assets are not owned under that person's name. They're owned by the trust or they're connected to the trust. And so at that point, we're able to completely avoid probate, and that is something that we would definitely want to do. In California, probate cases, we do a lot of probate cases, as I had mentioned earlier. Probate cases, they cost a lot of money in most cases. The fee associated with probate is a statutory fee. And so these fees, for example, let's say you have $1 million home, and unfortunately something happens and you haven't done a trust, and so now the house is in the probate. The minimum statutory fee for a house that is $1 million is $46,000. Let's say you have the same home and you owe $900,000 on it. The probate fee, the statutory minimum probate fee, will be $46,000. It doesn't really matter what you owe on the property. The percentage that state of California has is calculated based on the gross value. So the reason when you have a home, when you have a business and those sort of assets, the reason doing a trust becomes more important is that we could avoid this whole probate process. The fact that it costs a lot of money, the fact that it takes so long, like I mentioned, the average time is about 1.5 years. So for those reasons, you don't want your kids to go through it, unless you don't like your kids, unless they're not listening to you. At that point, you let them go to probate, let them deal with these things for 1.5 years and get less inheritance. But the reality of it is, if you're here listening to this Q&A session, you probably do care about your kids and you want to put something better in place. All right, so that was the explanation of differences between a will and a trust. Let's see, I think Mehdi had sent a question. Can some of the assets be transferred upon death of one of the trustees? I'm not sure if I understand the question correctly, Mehdi. When you set up a trust, there's like 3 main players in a trust. You have the person who creates the trust. They call that person the grantor. But just to mess with us, they also sometimes you'll see documents that says settlor, trustor, trust makers. There are 4 different names that is used for the person that creates the trust. It really doesn't matter which name is used. But you have the grantor, that's the person who creates the trust. Then you have the trustee, that's the person that manages the trust. And then you have the beneficiary, that's the one that gets to benefit from the trust. That's the position we all need to be at. With beneficiaries, however, that role is bifurcated, and you have a present beneficiary of the trust, and then you have future beneficiaries. So again, when we're setting up a revocable living trust, you will be the present beneficiary of the trust, and your kids will be future beneficiary of the trust. And so, okay, so Mehdi is saying when one of the grantors die. So the reality of it is, if you have a trust and you have transferred your property into the trust, at the time one of the spouses passes away, the property is already inside of the trust, so it doesn't matter. Let's say you set up a trust, you transfer some of your assets in there, but you buy another home and you don't transfer. Let's say you, for some reason, you took title under your spouse's name and your name jointly as joint tenants or as community with right of survivorship. And then all of a sudden, one of the spouses passes away. In that scenario, the surviving spouse will be able to transfer the property into the trust. There are some additional documents that would have to be filed. There's an affidavit of death of joint tenant or affidavit of community property owner that would have to be filed, and then an additional grant deed that would transfer the property now from the surviving spouse's full name to the trust. So yes, it can be done, but one of the things that you got to keep in mind is that it really doesn't matter how great your trust is. If your assets are not inside of it, we're still not really doing good planning. We got to make sure that you transfer the assets in there. Real estate is probably the easier one. The ones that I see most of the time outside is the client's corporation. Let's say you have a small corporation, you have a restaurant, you have a business, and most cases I see people own the shares of their corporation under their own personal name. If something happens, even if you have a trust, that doesn't mean that this corporation is involved or it's connected to it, and it'll take longer to get things done. So funding your trust becomes very important. All right, so let's see. Let's see if I have any other questions. So if you're here today, you're joining me on a Q&A session, estate planning and trust planning question and answer. And the goal of this webinar is for me to hopefully answer some of the questions you have about estate planning and help you sort of um, figure things out on your end. Um, I do have this Q&R code here on the side of the screen. So if you're looking to schedule a free discovery call with our office, you could scan this Q&R code and then schedule it yourself, or you could actually call our office right now, and we'll answer, and we'll be able to schedule a 15-minute discovery call. The goal for this call is to talk to somebody at our office. Maybe there is something else that you need to figure out and have some questions. And then after that, we could figure out if we're a good fit for you, and we could help you to set your trust. We do a lot of trust planning. So if you haven't set up a trust and you're looking to set up a family revocable living trust or any type of other trust, we could help with that. We do form limited liability companies. We do form corporations. We do a lot of asset protection planning. So if you're a real estate investor and you have multiple properties, we have many, many clients that we help out. I wrote a book not too long ago. I think I have it here. One second. Called Estate Planning for Real Estate Investors. And you could buy this book on Amazon. If you search my name, Ali Talai, it'll show up. It's a great book. If you're a real estate investor, obviously it will be fantastic. But if you're not a real estate investor, as long as you have a property, let's say a home that you reside in, this book would still be very helpful. It starts basic, kind of explaining some of the fundamental laws and rules and ways that you need to kind of think about estate planning. And then it grows in and builds on top of one another and talks about more advanced planning and limited liability company, Wyoming holding LLCs, and all these different type of irrevocable trusts. So if you have any questions, you could ask the questions in the chat box. You could ask your question, and I will do my best to answer. All right, Mehdi, one more question. It says, property to be transferred to my daughter, even though my wife is still alive, can it be transferred? So Mehdi's asking a good question. His question is that he wants to set up the trust in such a way that at the time he passes away, that some of the properties they own, him and his spouse own, is transferred to his daughter at that point. That's possible. In California, we're a community property state, and I'm assuming, Mehdi, you bought these properties at the time that you were married. So then that means the properties are community property. However, when the first spouse dies, we can set up the trust in such a way. One way would be that we say, whatever share that belongs to the spouse that passed away. So again, 100% is community property. When one spouse dies, 50% is allocated to spouse that is alive, and then the other 50% is allocated to the spouse that passed away, and it could go into a trust that would hold the trust for them. One option is that I could say, when I'm not around, I want my 50% to go into a trust, but I don't want to distribute it to anybody yet. I'm going to leave it in that trust so my spouse can use it. Sometimes people say, I want my spouse to have the same sort of lifestyle we had together. And then the trust will say when both spouses passed away, then that portion could go to the kids. But it doesn't have to be done that way. I could set up a trust and say, hey, when I'm not around, I want my 50% or a portion of that 50%, whatever my allocation of that community property is, I want that to go to my daughter. And so that could definitely be done. It just requires a little extra careful drafting in your revocable living trust, Mehdi. When we get into trust and real estate, one of the questions or concern is, I set up this trust and I go ahead and transfer my real estate in my trust. Will the property taxes on my real estate reassess? And that's definitely a legitimate question because, especially in California, if you had the property for some time, you're probably paying property taxes at a much lower assessed value than if you were to buy that same property today. So in every estate planning that we do, property tax planning becomes as important as the actual estate planning. We want to make sure that this transfer does not cause a reassessment, or at least if it's going to, we know it and we're willingly entering into this thing. The good thing is that when you make a transfer from your personal name and into your trust, into a revocable living trust, even though we have made a change in ownership, the county usually reassesses property taxes if there is a change in ownership. And so obviously we create a trust, it goes from your name to name of your trust. That is a change in ownership, but there is an exemption that says if you create a trust and it's a revocable living trust, then the county will not reassess the property taxes. So you could do it, it won't be reassessed. The one thing you got to be careful is that, you know, you file this document with the county and it gets recorded, and in our case, we, you know, there's a bunch of different forms that gets filed with it to try to really prove to the county that everything has been done correctly. However, most of the time, county will send you a letter saying, send us a copy of the trust. They want to confirm that, you know, yes, you did say this is a revocable trust, but they don't really know. So you just have to be on the lookout for any letters or any documents that the county may send to you requesting copies of the trust. Or if you transfer into an LLC, a lot of time I have clients that have rental property and they're transferring it into a limited liability company, and it's the same thing. Transfer would cause reassessment. However, as long as we have an exemption for it and we could transfer it into a LLC and not have the property reassessed. But you just got to be on the lookout, because in most cases, the county will send you a letter. If you're in LA County, it'll be probably like 2 months afterwards that they'll say, send us a copy of the trust, send us a copy of the operating agreement of the LLC. And you just got to make sure that if you are doing this sort of planning, you do have a trust. I mean, obviously you do, but you have the agreement. So sometimes I have clients that maybe created a trust a long time ago and now they want to transfer the property in there, but they don't know where the trust document is, or they created an LLC and they're transferring a property into it, and the LLC doesn't even have an operating agreement, which is the worst. Or they don't know where it is. So you want to make sure before you actually make the transfer and record it, you've already checked, you know, you have it. And then it's not so much just having it. We got to make sure it's got the right language that it won't cause any reassessment. It's not like we're just going to send them the operating agreement. They're going to, you know, put a stamp of approval on it. It has to have certain requirements. So again, doing those sort of transfer, you 100% want to talk to somebody that is a little bit more familiar with those sort of things. All right, let's see what else I could come up with questions here. Let me see what I see. Meanwhile, if you need to schedule a free discovery call with us, please use the QR code on the side, or you could call our office to set up something to get more information about your estate planning. All right, so follow-up question Mehdi has. He says that even though it's a property, it's a community property, they still want 100% of the property to be transferred to his daughter. That is fine. If you and your spouse want that, then that's how the trust is going to be written. It's going to be that the two of you are saying at the time the first spouse passes away, let's say, unfortunately, if it's you, Mehdi, we're going to say 100% of so-and-so property is transferred to your daughter. And as long as both spouses have agreed, that is completely fine. That can be done. All right, let's see. Any questions? Please make sure you log them in, or not log them in. You put them in the chat for me. All right. You're welcome, Mehdi. One of the other questions I get is that a lot of times clients tell me that they want to set up their trust in such a way that something happens to them and they're not around, and now the inheritance is going to their kids. The kids are going to inherit the home, the bank account, the rental property, whatever it is. They want to make sure it's done in such a way that if something happens to their kid, they get in a lawsuit, they get in a car accident, a divorce, bankruptcy, one of those unfortunate things, that the inheritance is safe. They don't want the inheritance to be part of the settlement agreement. And so the question is, how do I preserve and safeguard my inheritance, my assets when it goes to my kids? And the reality is, there's really two main options. The two options that you have when you set up your trust, at the end of it, when it gets to the place that now you got to make distributions, you could set it up so that there's 100% distribution or outright distribution. The percentage could be different, but whatever percentage you're giving to the child, it goes outright to their personal name. That's one sort of contribution or distribution. The other distribution is that we will create a trust, or you will create a trust inside of your trust. You help with our help, and the distribution for the beneficiary will go inside of this trust. So we call it inheritance trust. So you could create an inheritance trust in your revocable living trust, and that trust sort of sits there. Nothing happens until both parents have passed away. Then it sort of springs into action. And now any distribution that belongs to that particular child will go into his or her own trust. And you could even name the same child as the trustee of his or her own trust. The difference between these two, if the distribution is outright to the child's personal name, now he or she's deemed owner and is the real owner of the properties. So if something happens and the child goes and gets in a car accident, there's a lawsuit, something goes wrong, the assets that are under his name or her name would be susceptible to claim of creditors. But in the other scenario, if you set up the trust and you have these inheritance trusts built in there, and now the property is not under the personal name of the child, but rather it's in their trust, it would be much, much, much more difficult for a creditor to be able to attach that trust. And so that is definitely the best way that you can set up your estate plan to make sure your asset stays within family bloodline. If unfortunately a child passes away, it doesn't go to their spouse, but rather goes to the grandchildren. If your child didn't have any children at that point, it could go to the other siblings. So we could kind of keep it within the family bloodline, and that will help. So that would be the much better way to set up your estate plan, and that could guarantee that the asset stays within your family bloodline. It guarantees that you have provided a great deal of asset protection against unfortunate possibility of a divorce for a child, or a bankruptcy, or a lawsuit, or car accident, those sort of things. And it's a kind of a planning that the beneficiary cannot do for themselves. One of the reasons the trust that parents create for their children, these inheritance trusts, have the highest level of asset protection is because two reasons. One is that the child is not creating it. I'm not creating the trust for me. Somebody else is creating it for me. My parents are creating it for me. And then the second aspect of it, and second reason that it gives you a lot of asset protection, is that it provides, I'm not putting my own assets in there. It's my parents' assets, somebody else's assets that goes in there. So it's a great way to be able to set up your trust, inheritance trust for your children, and it would provide a great deal of asset protection. All right, so let's see. So Nina asks, can't incapacity planning be done using a power of attorney instead of a trust? Nina, that's a good question. And we usually use both of them. We do powers of attorneys, and then we also do a trust. And the difference between the power of attorney and a trust is, so let's say we've created a trust, right? And you transfer the real property into the trust. The real property, something happens, we need to obtain a mortgage, we need to sell the property, anything to do with the assets of the trust, The trustee is able to fully take care of that, not the power of attorney. And then the other thing is, when the person passes away, if we have the trust and the power of attorney, the trustee of the trust will continue to have power versus a power of attorney agent. The power of attorney agent, as soon as the person passes away, that power of attorney doesn't have any power. Usually when you are using a power of attorney is in a case or cases that the assets are not owned by a trust. So for example, let's say you have a retirement account. We are never putting the ownership of the retirement account into the trust. And the reason is that if you change the ownership of your 401k, it's going to be a taxable event. And that's probably not something anybody wants to do. So in a case like that, we may update the beneficiary designation form and say, hey, when I'm not around, pay this money to my trust. But the ownership is always under my name. A lot of times, life insurance, I may keep the ownership under my name and name the trust as the beneficiary, or maybe a bank account. The ownership is under my name, but I say, paid on death, upon my passing, pay it to the trust. In those scenarios, something happens, the grantor, the person that created the trust, or the principal of the power of attorney is mentally incapacitated. The trustee cannot do anything for the assets like the 401k and the bank account and the life insurance, because they're not owned by the trust. And so in that scenario, we are going to use the power of attorney. So the better way is having both of them together, so then you can sort of tackle anything that could come up possibly in this estate planning world. But great question, Nina. Thank you. All right, let's see. Oh, I see, Nina, 30 years. No, it's too late. Increase property tax. So there was another question I think Mehdi had, talking about how to prevent challenges to the trust. So how to prevent challenges to the trust? There are different things that we can do. One, it really helps that you have actually hired an attorney to draft the trust, or your, estate planning, a will, whatever it is that makes most sense. One reason is that now there is a third party who's a fiduciary, and that person can testify as far as how this whole thing happened. Were you by yourself, or was there somebody else there that could have maybe in some way or shape force you to do certain things? So again, having a counsel in place, that helps a lot. Sometimes we get another attorney to provide opinion as far as mental capacity and those sort of things. Sometimes we have the client go and actually get a mental examination from a specialist or physician to make sure that they're fully capable of making these sort of decisions. One of the provisions that you could put into a trust is a no contest clause. And what a no contest clause means is that it means that if I'm a beneficiary of the trust, let's say I'm getting 20% and my brother is getting 80%, and I don't like it, and I just gonna go file a lawsuit and say, I don't like this, I'm not happy with this thing. The no contest clause says if you just contest the trust just because you don't like it, like the distribution, you're gonna get nothing. So in a situation like that, a lot of times if the beneficiary could lose a good portion, even though maybe they think they were entitled to another 30%, it doesn't matter. That still will sort of preserve the structure and make sure that it would not they would not challenge it. Whoever is going to challenge the trust, obviously they would have to have some sort of standing, meaning that they have to have some sort of interest. For example, your trust, unless you like to name me in your trust, if you don't, I have no standing to go bring a lawsuit. So again, usually it's one of the immediate family. And then the other thing is they have the burden of proof. And a lot of times in those scenarios, in those cases, they have to the way they could challenge the trust is that they could say, my dad was completely out of it. He had no mental capacity to make a trust. He was sick, he had dementia, something like that. So they have the burden of proof. So it's not easy, especially if you've done your trust, when you were younger. If you waited until you're 99 to write a trust, those sort of claims could be more easily brought, and so those are some of the ways to hopefully try to prevent some of these things. In United States, there's really no right to a beneficiary. As a child, I don't have any right. My mom and dad could say we're giving it all to the shelter, or their friend, or whoever they want to give it to, and I have no right. So that lessens some of the fightings and things like that in general. However, we see a lot of fightings for sure. All right, so another question. I'm going to try to read. Some of these questions are long. All right. Do you know if it's too late to avoid paying the increased property taxes? My stepdad recently passed away, and unfortunately, the proper paperwork for the house settlement wasn't in place. Okay, so it's about property taxes, Nina. It looks like my stepdad recently passed away, and unfortunately, the paperwork wasn't done right, and now your brother is asked to pay. There is a 3-year window to file these parent-child exclusion forms. Recently, I don't know when your dad passed away, but if it was, well, I think you said recently, right? Yeah, recently. So Proposition 19 became law February 16, 2021. And people that passed away before that, there was lots of great rules as far as how you could get the properties transferred to children without having any reassessment and things like that. But now, after Prop 19 is the law, there's really not a whole lot that you can do. And there are some restrictions and requirements when it comes between step parents and stepchild. But the main thing is that the only exclusion left is for a primary residence, and it has to be the parent's primary resident, and then the child has to make that property his or her own personal residence as well within 1 year. And then the limitation is only $1 million. So there is, depending on what the property value is and things like that, the property taxes could still go up. However, even if you forget, so there's a 3-year window you could file. If it goes even past that, which it doesn't sound like it has, you still have the ability to file the exclusion and try to have the property taxes reduced. So Mehdi asks, after we restate the new trust, can't we distrate the old ones? I probably would say no, don't do that. If you have a trust, there's really 2 options when you want to update it. One is that you could restate the trust. That means when we do a restatement, it's a completely brand new trust. The only thing we keep is the name of the trust. And the only reason we do that is because, let's say you have a property, your home is under the trust, your investment account is under the trust, your rental property is under the name of the trust. If we restate it and then change the name as well, that means we're going back to the county to record more new deeds, and going back to the brokerage account and all that stuff. So just extra work for no reason. So that's why we keep the name. This is almost the same thing as, imagine you have your home, you completely gut it out and do a remodeling, and it's now a brand new home in there, but your home address didn't change. It's still the same thing. So when we do a restatement, we keep the name of the trust. Everything gets changed, and it's really a brand new trust. The other option is that you could do an amendment to a trust. Usually amendments would be fine if we're making very small changes to the trust. Maybe the name of the trustee, a successor manager of the trust, successor trustee of the trust is being changed. Or maybe you're making changes to the distribution percentages or the fraction. Those amendment was fine. However, if we're doing more of a bigger change, or if the trust is really old and now we got to really update way too many places, it'll be probably more efficient the cost-wise, and also the way the document will look to just restate it. So when you restate it, you do have a brand new trust. But we had cases when clients, children of the parents that passed away, they were going to sell the home, and the title company still wanted to see copy of the initial trust. So I would probably keep it, Mehdi. All right. I hope you're enjoying this Q&A session here. If you're looking to get more information about your particular situation or your estate planning, you could scan this you can scan this QR code here on the side of the screen, and you could schedule a 15-minute free discovery call yourself, or you could call our office right now, 818-285-2850, and we can help you schedule a call and try to answer some of your questions. And then if it's a good fit for both of us, we could try to help you put your estate plan together. That is all we do. We are a trust and estate planning law firm. We do from basic, easy estate planning all the way to super, super complicated, high-end estate tax planning. I file gift tax and estate tax returns and asset protection planning and all those sort of things. We do probate and trust administration, but we sort of stay focused within the estate planning arena to hopefully be able to help our clients more. I'm a trust attorney. I'm also a tax attorney. I became a lawyer first and then decided that if I'm going to stay in the estate planning world, having some tax law knowledge would be useful. So then I went back to law school and spent another 2 years and got an advanced tax degree. So a lot of the plannings that we do we take in consideration a lot of tax planning as well. All right. Mehdi asks, is a step-up basis automatic after death of grantors? It's not, when it goes into a trust, it's not exactly automatic. So step up in basis, let's say you have purchased a property for $1 million and now it's worth $3 million. If you were to go to sell this property, and let's say you're just going to sell it, there's not a 1031 exchange, IRS will say, well, you bought it for $1 million, you're selling it for $3 million, there's a $2 million increase in the value of the property, so you'll pay capital gains tax on the $2 million. There are some adjustments and stuff like that to the basis or deductions. We're going to leave that alone for this example. And so, you pay $600,000 or so in capital gains taxes. Now, let's say you don't sell the property and unfortunately you pass away, and now the property goes to the kids. The questions the kids will have is, well, we're thinking to sell the property. What would be our capital gains tax? And the reality of it is that when parents pass away, or whoever that owned the property, if the property was under their personal name, they passed away, they will get a new basis in the property. In most cases, is a step up in basis. So now, if the value of the property was $3 million at the time, let's say the last spouse passed away, the $1 million tax basis now becomes $3 million. So now, if the kids decide to sell it, there's no capital gains tax. That $600,000, $500,000, $700,000 of capital gains tax just went away. And obviously that becomes really important in these sort of planning. When you place a property into a trust, now when the first spouse dies, you get a full-on step up in basis. When the second spouse dies, it really depends how the trust is set up. There are cases, and I see them often, unfortunately, that the trust is designed for estate tax planning and not capital gains tax planning. And in those scenarios, if a trust is designed to avoid estate taxes, when the second spouse dies, there's no step up in basis on that property or portion of the property that is in a particular type of trust. So what becomes really important for you if you're looking to set up your estate plan, we call it capital gains tax election, but you just got to make sure that whoever is going to set this thing up for you, that the focus of the plan is to make sure that we're getting step up in basis at the time the first spouse dies, at the time the second spouse dies, with the only exception that if you are super wealthy and your total estate value is greater than 10, 15, 20, 30 million, at that point, maybe having an estate tax planning in place becomes more important than just getting a step up in basis. So it just depends where you're sitting as far as total value of the estate, and that would sort of control how we're going to set up your estate plan. I'm going to have the Q&A going for another 10 minutes or so. So if you have any questions that you'd like to ask me, please go ahead and put it in the chat box. Mehdi, you are welcome. Thanks for attending. Let's see. All right. Let's talk about a little bit of asset protection planning. I work with a lot of real estate investors and Airbnb owners and short-term rentals and those sort of things. So a lot of time the question is, I want to make sure if something happens and my tenant falls or they bring a lawsuit against me, that my assets are protected. And a lot of times we could do planning using limited liability companies, LLCs, or LP, limited partnership. A lot of times we use Arizona limited partnership. A lot of times we use Wyoming LLCs, holding LLCs for different reasons. But in general, when you own a property under your personal name, and let's say there's a lawsuit, they get a judgment, it's the easiest thing for the creditor to place a lien on the property. I mean, the first thing they'll do, they'll go to whatever county you're in, and they'll ask the county to record the judgment on whatever number of property you have. So if you got 5 properties, they're going to record their lien on all 5 properties. And so that's the easiest thing. So we want to make sure we do something that is not easy, and really really asset protection planning is really about making it more difficult, so that maybe they won't even go after the assets, or at least it allows you more flexibility and allows you some leverage to be able to negotiate with them in whatever case it is. And so when you transfer the property into an LLC, limited liability company, one of the first thing that it will do is that it will remove the property from your name. Now the property is not under your name. So now if that same creditor just goes to the assessor, not the assessor, to the county and says, hey, record this thing for me, they're going to come back and say, well, we can't find anybody with that name that owns any property in this particular county. So again, it makes it more difficult. And then when you transfer the property into the LLC, you don't own the property. The LLC owns the property. You own the membership interest of that particular LLC. And again, going after the membership interest becomes more difficult. And so that's one of the strategies. It gets pretty complicated. And again, it could get complicated depending on what's the value of the state, how many properties do we have, how much money do we want to really spend on an asset protection. Asset protection planning is like building a high-rise building or building a building. And it could be a 2-story, 3-story, or it could be a 50-story. And so it just depends on what we want to do. The other thing is that LLCs are used a lot. And a lot of times we use irrevocable asset protection trust. And most of the time, not so much for rental properties, most of the times for personal residence. So if a client has an expensive personal residence and they have a lot of equity in there, asset protection trust, irrevocable asset protection trust can be very useful. The big difference is that when you place something in an LLC, you still own the asset. The form of it changed, right? It went from a property into a membership interest, and people just don't like membership interest, or creditors don't like membership interest. It's like me asking you, would you like me to give you $100 or $100 gift card to Chuck E. Cheese? And unless you have kids, young kids, you probably want the $100. So the LLC kind of does the same thing, kind of changes the form into something that most creditors don't like. When you compare that to an irrevocable asset protection trust, what we're doing at this point, we're saying you have this property, you transfer it into this trust, you don't own it anymore. So now if somebody files a lawsuit against you, they're not getting access to that property because you don't own it. So it provides greater asset protection, but keep in mind, if we're saying you don't own it, it means that if it generates any income, you don't own that either. You do not own that either. So that's why a lot of times we don't put rental properties in there. And most of the times, if you just have a personal residence, that would be a better sort of asset to go in there. All right, we're getting close to the end of the session. If you have any last question, please go ahead and put it in the chat box. Mehdi asks another question that says, can the surviving grantor change the provisions of the trust? And that would only depend how your trust is written. If a trust is written that says, after my passing, everything goes to my surviving spouse and she can do whatever she wants to do, then that means yes. After the first spouse dies, the surviving spouse can change the term of the trust, can remove a beneficiary, add a beneficiary, change the distributions, anything. If the trust does not do that or does not say that, and it divides the assets into two sections, half for the surviving spouse and half for the spouse that passed away, then the surviving spouse can change whatever share he or she has. However, that other 50% that belongs to the spouse that passed away, that cannot be changed. All right, let's see. If you need to make a phone appointment, you can use this schedule-free discovery call, and that would give you a 15-minute slot. You would schedule it. You'll get the times that were available, and you'll schedule it, and we'll give you a call on that time and try to answer any questions that I wasn't answered here, and kind of help you and figure out how you could make the appointment and move on and to the next appointment if everything seems to be working out. Or you could call us at our office at the 818-285-2850 number here. Those are the two ways. Let's say, Nina. If you have a trust in California and you sell your property, move to another state, and don't buy property, do you need to cancel that trust and create a new one in the new state? That's a great question. What happens? If you create a trust in California, and let's say you have a property, you place it in there, the California trust that is created under California law is effective and valid in all the other 49 states, anywhere in the United States. So if you move from California and you go to another state, in most cases, you don't need to change anything within the trust. Again, let's say you have larger estate, then it's always a good idea to have an estate planning attorney there review the trust. But in most cases, you're not required or don't need to update the trust document at all. What the documents that a lot of times do need to get updated, they're usually like the ancillary documents, like the advanced healthcare directives, financial power of attorney, HIPAA authorization forms. In California, the law in California says that if somebody comes in, let's say from Pennsylvania, and they've done their trust there, they've done these sort of documents as well, healthcare and financial and all that stuff, as long as they were legally and adequately done in that state, then California has to accept it. So again, they're still fine. You don't need to. But what I run into a lot of times is that when you take that document to the bank, the California version of it, the bank has seen it, time after time. So they're familiar with it. Things will most likely go smoother than if you go in there with another state's form. It might just be a little bit more difficult to get things done. So maybe you update some of those ancillary documents. And then if you create a trust and you place your home in there and then afterward you sell the property, if there's nothing in there, technically the trust kind of goes away. One of the requirement for a valid trust is corpus, assets of the trust. And the thing is, if you sell your home, Most of the trust that we do, we make a general assignment saying, whatever you own is to be transferred in here. It's not enough for like real estate. Those you need actual document that says the property's transferred. But it really keeps the trust intact because you got a bank account, you got your car, you got your personal items. Those are again sort of coming into the trust. So the trust still has asset, but for some reason, if you don't want it, you just kind of um, don't use it anymore. There's really no need to officially cancel it. If there is no money in there, if there is no home in there, it's just out. But let's say you don't have anything in there, 5 years goes on, and then you decide to buy something, the trust still is still active. You could use the trust and take title under the name of the trust, and then it will still prevent the probate and all that stuff when we're not here. All right. All right, very nice. Yeah, we'd be more than happy to help you with your setting up your trust. Um, that would be that's something that we do. That's for sure. Mehdi asks, is POD better for bank accounts? POD is paid on death beneficiary, and with bank accounts, you have two options. You could just go to the bank and update the POD of the bank account and say, hey, I want to put my trust name as the beneficiary of the account. So now something happens, the trust writes a check to the trust, and the money comes in there. The other option is that you could rename the bank account under the name of the trust. So now instead of showing your name, we'll show the name of the trust. Something happens, you pass away, it doesn't matter. It wasn't under your name, it was under your trust. The only two difference, it's more difficult usually to get the bank to change the name of the entire bank account. In most cases, I've seen that the bank will say, you got to close this account, open up a new account. And so sometimes that becomes a hassle, especially if you have automatic payments and those sort of things coming out. But the difference really between the two is, let's say it's a POD account and my parents pass away. Yes, the bank would write me a check. Let's say there was $100,000 in there. I'll get a check, or as the trustee of my parents' trust, but and then they will close the account. I will have no access to look into the statements or the history of the bank account to see who was paid, who was not paid, or, I don't have any access to the bank account anymore. When you compare that to if the bank account was owned under the trust, the account doesn't close. So I would just have to provide them with documents that I'm now the successor trustee of the trust, a death certificate, and then I get placed on the bank account, and I could have obviously access to the 100,000, plus I could see whatever history that was in the bank account, checks that were written out, or whatever else that was done. So that's really the two differences. All right. It was I'm happy that I got the opportunity to come here and speak with you fine folks. I hope you enjoyed the question and answer. I hope I did answer your question. If you have more questions or something else comes up, you could always call our office, 818-285-2850. We're in Woodland Hills. We service clients anywhere in California. As long as you live in California, we could help you. You could have properties anywhere in the United States. That's not a problem, but you have to be a resident of the state of California. And we do a lot of Zoom meetings. We have traveling notaries that will take the documents to you to get everything signed. And we're a full service estate planning firm. Okay, thank you so much.